Raymond was diagnosed with kidney cancer in 2021, 13 years after he came home from Iraq. He had burned trash and debris in open pits throughout his deployment. When he filed a VA disability claim, the VA denied him because he could not prove his cancer came from his service. The PACT Act, which became law in 2022, changed the rules for veterans like Raymond. VA cancer claims are now presumptive for dozens of cancers linked to burn pit exposure and toxic environments, and the VA must pay without making veterans prove the connection themselves. I'm Travis Studdard, a veterans disability attorney, and this video will tell you exactly who qualifies and how to file. Let me start with what the PACT Act actually did, because there is a lot of confusion among veterans about what it covers and who it helps. Before the PACT Act, if you developed cancer that was potentially connected to your military service, the burden was on you to prove the connection. That meant getting a nexus letter from a doctor who would say your cancer was at least as likely as not caused by your service. For toxic exposure cancers, that was nearly impossible. Burn pits produce smoke containing carcinogens, heavy metals, and dioxins, but establishing a direct line between exposure and a specific cancer diagnosis years later required the kind of medical evidence most veterans could not get. The PACT Act changed that system by creating presumptive service connection for dozens of cancers. Presumptive means the VA assumes the connection exists if you meet certain criteria. You don't have to prove how your cancer developed. You don't need a nexus letter. You do not need to fight the VA's argument that there was no documented exposure. If your service locations and dates align with the presumption, the VA is supposed to grant service connection. Here is who the presumptions cover. Veterans who served in Southwest Asia, which includes Iraq, Kuwait, Saudi Arabia, and the surrounding region, on or after August 2, 1990, during Operations Desert Shield, Desert Storm, or later operations are covered. Veterans who served in Afghanistan, Uzbekistan, Syria, Egypt, Jordan, Lebanon, Yemen, or Djibouti on or after September 11, 2001 are covered. That is an enormous number of veterans, and many of them do not know that their cancer may already be a presumptive condition. The presumptive cancer list under the PACT Act includes a wide range of diagnoses. Kidney cancer is on the list, respiratory cancers, including lung cancer, are on the list, head and neck cancers are covered, including certain head and neck cancers which may include thyroid, depending on VA interpretation. Reproductive cancers, including uterine, ovarian, cervical, prostate, and testicular cancer, are covered. Melanoma is covered. Pancreatic cancer is covered. Lymphatic cancers and certain lymphomas are covered. The full list is extensive, and if you have a cancer diagnosis and you served in one of the covered locations during the covered time periods, your first call should be to a veterans disability attorney. Raymond's kidney cancer was on the presumptive list. His service in Iraq during the covered period qualified him for presumptive service connection. He no longer had to prove his cancer came from burn pits. The VA had to accept the connection. He received a 100% rating for active cancer. VA cancer ratings work differently from most disability ratings. When you have an active cancer diagnosis, the VA rates you at 100% for the duration of active treatment. After treatment ends, the VA reevaluates based on any residual effects. If your cancer goes into remission, you may be reduced from 100%, but residual conditions such as organ damage, fatigue, cognitive effects from chemotherapy, and other lasting impairments can continue to be rated. The active treatment rating at 100% pays approximately $3,938 a month at current VA rates for a single veteran with no dependents. For veterans with dependents, the payment is higher. And because cancer treatment often lasts months or years, the total back pay and ongoing payments can be significant. Raymond received back pay and ongoing benefits at 100% during his treatment. When his cancer went into remission, we documented his residual conditions, including reduced kidney function and fatigue, and he continued receiving benefits for those lasting effects. There is an important distinction veterans need to understand between presumptive service connection and direct service connection for cancer. Presumptive connection covers veterans who meet the geographic and time period criteria. Direct service connection is for veterans who can show their cancer was caused by a specific in-service event or exposure, even if they don't meet the presumptive criteria. This matters because some veterans deployed outside the presumptive coverage windows or in locations not on the presumptive list, but still have strong evidence of toxic exposure. Direct service connection claims still require a nexus letter, but they remain available, and veterans in that situation should not assume they are out of options. Veterans who were denied for cancer claims before the PACT Act should also know that past denials can be reopened. If you filed a claim for a cancer that is now on the presumptive list and the VA denied you before 2022, you can file a supplemental claim using the PACT Act as new and relevant evidence. The law also allows retroactive payments in some cases, but generally not before the PACT Act went into effect in August 2022. Veterans who would have qualified for benefits earlier but for the pre-PACT Act rules may be entitled to back pay going back further, but they must prove entitlement on a non-presumptive basis, meaning they cannot make use of the PACT Act presumption. This is one of the most misunderstood provisions of the PACT Act, and it represents real money for veterans who were denied. The VA has not handled PACT Act claims perfectly. There have been processing delays, claims that were misrouted, and claims where the VA failed to apply the presumption correctly. Veterans with cancer claims under the PACT Act should not assume the VA got it right just because a decision came out. If your claim was denied, or if you received a rating lower than you expected, a review of the decision is worth doing. There are also secondary conditions in cancer treatment that veterans often overlook. Chemotherapy and radiation can cause lasting damage to other organ systems. A veteran who developed kidney damage from cancer treatment may be entitled to a separate rating for that condition. A veteran whose cancer spread to secondary sites may have multiple ratings that stack. Veterans who develop cancer as a result of a service-connected condition, such as a veteran whose Agent Orange-related diabetes contributed to a cancer diagnosis, may have additional service connection arguments available. We will get to Agent Orange and the PACT Act in a moment. One thing Raymond did not know when he first came to our office: his cancer was not his only claim. His treatment had caused fatigue severe enough to affect his daily function, and the reduced kidney function from his cancer and surgery was a separately rateable condition. By the time his initial active cancer rating resolved and his treatment ended, he had multiple conditions contributing to his combined rating, and he continued receiving substantial benefits even after remission. As I mentioned, there's also the question of Agent Orange, which was a separate toxic exposure program that predated the PACT Act. Veterans who served in Vietnam, Thailand, or along the Korean DMZ during certain periods have long had their own set of presumptive cancers under Agent Orange provisions, which have been part of federal law for decades. Those cancers include certain soft tissue sarcomas, non-Hodgkin's lymphoma, chronic B-cell leukemia, Hodgkin's disease, and others. Veterans who served in those locations and periods should not confuse the Agent Orange presumption list with the newer PACT Act list for Gulf War era and global war on terror veterans. Both exist, and they cover different groups of veterans with different qualifying criteria. However, the PACT Act did expand the list of geographic locations for presumed herbicide exposure. Previously, only certain Thai-based veterans qualified for a presumption of Agent Orange exposure. Now, with the PACT Act, all U.S. veterans who served at any U.S. or Royal Thai military base from 1962 to 1976 qualify for that presumption. Other veterans are also presumed to have been exposed. For example, those who served in Laos from late 1965 to 1969, or in Guam, American Samoa, or Johnson Atoll, or the territorial waters of any of those, also now qualify for the Agent Orange presumption, although the required dates of service do vary depending on location. If you are unsure which presumption applies to you, or whether you qualify under either program, that is exactly the kind of question an attorney can help you sort out quickly. The two programs have different geographic and time period criteria, different cancer lists, and different documentation requirements. Getting this right at the start of a claim is much easier than correcting a filing that used the wrong legal basis. I also want to address veterans who are currently in treatment for a service-connected cancer and have not yet filed for TDIU or special monthly compensation. A veteran at 100% for active cancer may also qualify for additional compensation if the cancer or its treatment has caused the loss of use of a body part, certain types of severe disability, or a need for regular aid and attendance from another person. Special monthly compensation is a benefit on top of the standard 100% rate, and it can add several $100s to over $1,000 a month for veterans whose conditions meet those criteria. This benefit is rarely discussed, and many veterans in active cancer treatment are missing it. The PACT Act is one of the most significant expansions of veterans benefits in decades. But the VA is not going to call you and tell you about it. Veterans who served in the covered locations and have received any cancer diagnosis need to know this information, and the time to file is now. If you want to understand how secondary service connection works alongside cancer claims, check out my video on secondary service connection next. It shows how veterans build stronger combined ratings through connected conditions. If you have a cancer diagnosis and served in a covered location, Perkins Studdard can review your claim at no upfront cost. Subscribe so you never miss the information the VA is not going to send you.